Greetings to Dr. Rama. We are from Firm 16 that consists of Aina, Aisha, Lavanya, Aiman, Sarah, and me, Johan, will be presenting on our research on the admissibility and probative value of WhatsApp conversation as evidence in court. Internet has set the way of life by helping humans to communicate or to conduct business in the most convenient way. In this paper, the main focus shall be on WhatsApp application, an instant messaging application that is widely used in Malaysia. WhatsApp is the host of the conversation, but they cannot access what is being communicated between their users since it is an end-to-end encryption which protects the conversation from outsiders. However, does WhatsApp conversation be considered as evidence in a proceeding? An illustration for criminal trial, it can be said that there is a mens rea transpired for the commission of an offence. For another illustration of civil proceeding, agreement can be proven in the absence of written agreement. WhatsApp is being used routinely serves its own importance in legal proceedings with speedy disposal of cases. This paper will then dissect the operative part of WhatsApp conversation and the relevant provision governing its acceptance.
In 2009, WhatsApp was introduced as a cross-platform centralized instant messaging application, and to this day, WhatsApp have many productive functions that help make the communication process easier and quicker. And the root function of WhatsApp is to allow communication among people all over the world to send messages, images, video, audio messages, and location sharing. Thus, in time, WhatsApp have progressively become one of the most convenient and effective interpersonal communication all over the globe. United Kingdom became one of the countries that had taken part progressively in the growth of WhatsApp usage. Messaging applications plays an important part in today's digital communication, and therefore, as seen in the UK, WhatsApp came in as one of the most popular applications alongside Facebook and YouTube, with a reach of 58% as of January 2018. And statistics in 2021 further shows that the current total number of active users in WhatsApp amount to 30.1 million out of 62 million internet users in the UK. India also kept up to the modernization by conforming to its society needs. The government of India revealed a social media guideline called the Information Technology Guidelines for Intermediaries and Digital Media Ethics Code Rules 2021, which allow it to exert greater control over platforms such as WhatsApp. It is aimed to protect the privacy of online users in India, because there were several occasions previously whereby WhatsApp faced backlash due to its data sharing policy with its parent business. This has led the Indian government to voice out its dissatisfaction to WhatsApp, as it is expected for users to comply with it or lose all access. And therefore, WhatsApp has emphasized that it only applies to business messaging and not privacy chats. Malaysia too is at the top of the list, with 77% internet users using WhatsApp on a daily basis, and Malaysians becoming WhatsApp largest users with a reach of 51% in 2017. Due to its many advantages such as ease and speed in communication and information sharing, WhatsApp has become the top pick for Malaysians. Although WhatsApp has helped business people to market their ventures without spending a lot of money, former Communications and Multimedia Minister Datuk Seri Dr. Saleh Syed Kerwak also cautioned that WhatsApp had drawbacks, the most glaring of which was when it was used to smear a person's reputation.
Now we move to the next subtopic, which discussed about whether WhatsApp conversation fall under the definition of computer. Before diving further into this matter, it is vital to understand the definition of computer. Firstly, in United Kingdom, computer is defined in Section 5, Subsection 1 of the Civil Evidence Act 1968 as meaning any device for storing and processing information. On the other hand, in India, according to Section 21, Subsection I of Information Technology Act 2000, this section interprets that computer is the device or system which function as memory related converted to electronic as storage to store the input and output and also perform as communication facilities. Lastly, in Malaysia, the term computer has its definition under Section 3 of the Evidence Act 1950. In simpler words, this means that a computer needs to be able to store data and perform its other function like enabling communication with other devices. As previously emphasized in the previous subtopic, since WhatsApp conversation is a platform, aims to facilitate the communication process between people as well as has the ability to share images, videos, audios, and which further prove the capability of the applications to store users' data. Thus, WhatsApp functions are listed within the ambit of the definition of computer under all the aforesaid countries, namely United Kingdom, India, and Malaysia. We'll proceed to the second subtopic, which discusses about WhatsApp conversation, primary or secondary evidence. In discussing this issue, we did a comparison between three countries, which are Malaysia, India, and United Kingdom. Generally, in evidence law, evidence are categorized into two, primary evidence and secondary evidence. The court acknowledged that the best evidence rule would be primary evidence. This led to a pertinent question whether WhatsApp conversation will be considered as primary evidence or secondary evidence. As for the definition, in Malaysia, Section 62 of Evidence Act 1950 provide the definition of primary evidence. Meanwhile, in the same act, Section 63 provide the definition for secondary evidence. As for India, since Malaysia codified Indians Evidence Act 1972, so the provision which provide the definition of primary evidence and secondary evidence is pari materia with Malaysia, namely Section 62 and Section 63 of Indians Evidence Act 1972. On the other hand, in United Kingdom, there is no act that define both terms. Hence, Hadirman J, in the case of McFarlane and the Director of Public Prosecution and another, referred to Cross-on Evidence 5th edition at page 15 in defining primary and secondary evidence. It described that primary evidence is available by its existence, meanwhile secondary evidence is the copy from the primary existence. Now we move to the main issue as to determine whether WhatsApp conversation categorized as primary evidence or secondary evidence in three different countries. In United Kingdom, there are a few cases that discuss about printed evidence that generated from computer is admissible before the court as a real evidence. However, none of the cases had discussed whether WhatsApp conversation that usually be presented in the printout as illustrated in the case of Frost and Sekarma Limited and Ors is either primary or secondary evidence in United Kingdom. Next, in India, in the landmark case Anwar and PK Bashir, the judge propounded that electronically stored information is treated as a document, while the printed version of the document is treated as secondary evidence. Similarly, in the case of Najvot Sandhu, also discussed on printout call records and copies of which were categorized under secondary evidence. Although both cases did not discuss specifically on WhatsApp conversation, however, we can conclude that printout WhatsApp conversation are also will be treated as secondary evidence in India. In Malaysia, in the case of Mok Yi Che and Sovo Sendirian Berhad and Ors, the High Court held that printout WhatsApp conversation were documents produced by a computer falling within the broad meaning of Section 3 of the Evidence Act 1950. As such, those printout can be treated as any other printed document when it's come to admissibility. Such documents, therefore, treated as primary evidence which could be adduced before court by virtue of Section 62 of the Evidence Act 1950.
Another issue discussed in this writing is whether WhatsApp conversation is admissible in court proceedings. In this part of the writing, a comparative analysis was conducted between the United Kingdom, India, and Malaysia in order to identify whether WhatsApp conversations are admissible in court proceedings. Relevant provisions used in each country was referred, as well as its landmark cases, in order to fully understand the court's perspectives. It can be seen that the courts in the United Kingdom has accepted electronic evidence in both civil and criminal trials. This is stated under Section 3 of the Evidence Act, whereby computer records are admissible in courts. The electronic evidence is admissible in court as long as it is able to demonstrate its authenticity. Thus, the relevant party which intended to tender an electronically produced document as evidence in court must first establish the elements provided. Failure to fulfill all the elements will make the documents inadmissible in court. In the case of Force and others against the Karma Limited and others, the court decided that the WhatsApp conversations are admissible and can be used as evidence in the court. Meanwhile, in India, Section 2, Subsection 1T and I of IT Act has stated that mobile phones fall under the definition of computer. Hence, instant messaging such as SMS, WhatsApp conversations, and email messages are considered as electronic records. Therefore, Kalasha stated that these electronic messages shall be admissible as documents in accordance to Section 65, to be read with Section 65A and 65B of the Indian Evidence Act. But the conditions under this provision must be fulfilled. Therefore, it can be seen that the courts in India has accepted WhatsApp conversation as an electronic evidence and admissible in court proceedings per Section 65A and 65B of the Indian Evidence Act and amendment in Section 2, Subsection 1T and I, as well as Section 3 of the IT Act 2000. In Malaysia, documents produced by a computer are admissible by virtue of Section 90A, 90B and 90C of the Evidence Act 1950. In the case of Pani Selvam and the case of Lim Chun Hao, WhatsApp conversation is categorized as direct evidence and it is admissible in court as evidence. In conclusion, the main elements that must be fulfilled under subsection 90A regarding admissibility of documents produced by computers and of statements contained herein are similar to the one provided in the United Kingdom and India.
Now I will explain on our last subtopic, which is issue of proving identity and time. There are two main issues that are obstructive in admitting WhatsApp as evidence in the court, which are identity and time. Proof of identity occurs when there is insufficient proof as to the identity of the sender or the recipient of the instant messages, especially in the cases where the authenticity of the instant messages and the identity of the sender or the recipient is challenged. Next, time factor occurs when there is no clear detail as to when the messages were sent and read by the recipients. As in Malaysia, the Malaysian court classified the printouts of WhatsApp conversations as documents produced by a computer falling within the broad meaning of Section 3 of the Evidence Act 1950. In the case of Muhammad Azhar bin Abdul Halim versus Naza Motor Trading Sdn Berhad 2016, the industrial court deemed the screenshot of a WhatsApp conversation to be deficient and ultimately inaccurate. Furthermore, the claimant was able to show the court on how a WhatsApp message can be fabricated, resulting in a fabricated WhatsApp snapshot image of that message. Next, in Indian courts, WhatsApp conversations are viewed as an electronic record and are permissible as a conventional document. The Supreme Court of India declared in the case of State of Delhi versus Muhammad Afzal and others 2003 that the electronic evidence is lawfully admissible in the court. The Supreme Court must request a certificate signed by the individual who is using the computer resource and creating the data. That individual must accept complete responsibility for the document's legitimacy. However, the Supreme Court of India has called into doubt for the admissibility of WhatsApp conversations, once again due to the issues in proving identification of the real party and genuinity of the WhatsApp context without any fabrication. As in Malaysia, the Malaysian court classified the printouts of WhatsApp conversations as documents produced by a computer falling within the broad meaning of Section 3 of the Evidence Act 1950. In the case of Muhammad Azhar bin Abdul Halim versus Naza Motor Trading Sdn Berhad 2016, the industrial court deemed the screenshot of a WhatsApp conversation to be deficient and ultimately inaccurate. Furthermore, the claimant was able to show the court on how a WhatsApp message can be fabricated, resulting in a fabricated WhatsApp snapshot image of that message.
Coming down to the last part of our research, it appears that the court does not distinguish electronic evidence with WhatsApp conversation, via Mok Yi Chek case, as elaborated by my friends. Other way around, the court upon its deliberation may admit and not to admit WhatsApp conversation as evidence in court proceedings subject to relevant provisions in Evidence Act 1950. Nonetheless, the apparent issue on WhatsApp conversation to be used in court proceeding is in relation to proving identity and to prove time. It is on the burden of party who assert that WhatsApp conversation is being used by the alleged individual. Be it as it may, it will ramp up the cost to prove it, as it might need verification from third party, for instance from the MCMC, based on the Subarao or Kamalanathan case, a case pertaining to the 2014 UPSR test paper. The safeguard in proving the identity and time was stipulated in the decided case, which called for judicial discretion in assessing the evidence. It shows that judicial discretion in deliberating identity and time from WhatsApp conversation is also exercised in the India and the UK counterpart. To reinstate again, the duty of the court to make an assessment is being held in the Navi and MAP Sedana Berhad and Twinsi Sedana Berhad and others, where the evidence was successfully challenged on the fact that the computer was not in course of ordinary use and parts of the conversation were removed. And interestingly, in that case, Justice Shankar in Court of Appeal stated that Section 19A is there as a safeguarding mechanism to deal with such issues in pursuit of best evidence rule, what more in equipped with the advancements of technology. In so much with current evidence at 1950, Riza Salim 2006 argued that legal transplantation does not always serve as the best method in a way to provide a solution. He argued, for instance, corporate legislation in Malaysia, which is deeply rooted from its colonial master, the British, which does not reflect Malaysian context. Our court had dealt in line with progressive interpretation pursuant to evidence at 1950 should not be distilled with the importation of foreign jurisdiction, as it does not tell apart the differences. Throughout our research, we had shown that even though we have different of legislation, but the object of in answering whether or not to admit or not to admit and probative value of WhatsApp conversation had been sufficiently discussed in Malaysian cases. Perhaps only time will tell in pursuit of court activism to charter how WhatsApp evidence should be governed in the further time. With that, thank you.